Insightful briefing from Stuart Lowe, who is not only one of the partners at Mullins Lawyers, but Stuart's been supporting LASA Queensland's Retirement Living Advisory Group for many a year, quite particularly over the last, I think it's been 4 years since the Retirement Village Act has started to be reviewed, and it ended up coming into the Housing Amendment Legislation Act, which we know was passed just before the election was called. Prior to Stuart starting, I just wanted to take the opportunity to introduce everyone to Paul Murphy, who is LASA's recent, I think this is his 4th week, Principal Advisor in Retirement Living and Seniors Housing. And Paul is the go-to person for any retirement living or senior housing questions within LASA. Paul is based in this office, so we'll also send a link to contact information out. So Paul, would you like to take over and then we can go from there?
Very important briefing. As you know, the Act has changed, but it hasn't changed since then. But breakdown of what it is, and especially an hour and a half, quite that long. Questions about what's really the detail. So welcome again, everybody. Just to let you know that my telephone number and contact details are on all of the e-news that comes out fortnightly, and it's certainly obtainable here from the Queensland office. As a member services organisation, we are here to help you and to service you. So don't hesitate to contact us for any advice or assistance we can give you. Okay, thanks. Over to you, Stuart.
Thanks, Paul. Kerry.
Thank you.
Well, welcome everyone to today's discussion. We ran a session very similar to this at our office a few weeks ago when the bill had been introduced and the parliamentary committee had reported. So I know that some of you were at that, and today may seem a little bit similar to that. We're going to follow a very similar pattern, but I do know there are people that weren't at the presentation at our office. So for their benefit, I'll run through the detail of all the changes. But for those who have heard me speak on this before, I will endeavour to focus on what's changed since then, since that discussion, because there were some changes made to the bill before it got passed. And with the benefit of more time today, we can dive into it in a little bit more detail and have a bit more time for Q&A. I'm sure everyone's been turning their mind to how this is going to impact on their villages. So hopefully we can get some really insightful questions, and hopefully we can answer them. For those that I haven't met before, my name's Stuart Lowe. I'm a partner at Mullins Lawyers. I've been a property lawyer for 18 years or so, and all of that time I've been assisting operators to comply with the Act and keep their residents happy, and operate their villages. So today we're talking about these changes to the Retirement Villages Act that come out of the Housing Legislation Building Better Futures Bill. That bill amends a number of acts, not just the Retirement Villages Act, it also amends the Residential Services Accreditation Act, the Manufactured Homes legislation, but today we're just going to focus on the retirement village aspect. They are extensive changes, very extensive. We had extensive changes in 2006. I think these surpassed that in terms of their impact. They are going to require every every operator to take some action. They are fundamental changes and quite wide-reaching. And it's coming at a time when the industry is under a fair bit of sustained media pressure. So it's putting everyone on their toes, I guess. There's a lot to digest at the moment if you're a retirement village operator. Some of the bill was positive, I would have to say. There were some things industry had asked for. There are definitely benefits, but so much of it is not good. It is very problematic. And I have to confess, every time I read the bill, I get angrier and angrier that our elected representatives don't seem to be listening, to us at least. So I've given you a booklet there. I believe that was emailed through to people who have dialed in. And within that is two e-news that we've issued over the last couple of months around the bill. The earlier one in September is fairly comprehensive. It's much longer than we would normally issue for an e-news, but the intent there was to provide everyone with a resource. It's virtually a summary of all the changes. And then the shorter one, issued a couple of days ago, provides the updates in terms of what changed between the original bill and the bill as passed.
Where's the other?
So today, this is just an overview of what we'll be looking through today. I'll give you some background on how we've got to where we are, some general comments and observations from me. Then we'll talk about the new documents, the PIDs being replaced, I'm sure you're all aware. Exit entitlements and the 18-month buyback. Some new obligations around GSC, MRF, reinstatement and renovation. New behavioural provisions that impose obligations on both operators and residents. And then this trio of provisions around transferring or selling the village, redevelopment and village closures, which all follow a very similar pattern, and some changes around valuations and disputes. So the brief history of this, I guess over the last 4 or 5 years, this government and the previous government have been looking at our Act and what should change, and they've taken input from various stakeholders. Originally, with the previous government, we were dealing with Tim Mander, who was the minister at the time. Those discussions culminated in a report in 2012 from the Transport, Housing and Local Government Committee. The government then responded to that report in February 2013 as to how they would deal with the 30-odd submissions that the committee had made. 12 of them, they said, yep, we'll implement these straight away. A lot of those were fairly soft touch. We'll issue a fact sheet for residents' information. 6, they said, we will implement these, we just need to think a little bit harder about how. And 19, they said this needs a lot more consultation, we'll shelve that. And from memory, buyback was one of those. So there is overlap between what the previous government had envisaged and what we've got with this bill. But if you compare the two, the focus is very, very different. Under this Parliament, we've had Ministerial Working Party, industry stakeholder roundtable meetings. That culminated in a draft consultation bill, which was all very confidential. LASA received a copy, which they were not allowed to photocopy or email. I reviewed that, and through LASA we provided some feedback. Actually, a lot of the changes we asked for based on that draft, it was a pretty rough draft, actually were made. Not all, but several were made. which was pleasing. But since then, there's been less joy on that front. The bill was then introduced into Parliament on 10 August and immediately referred to the Public Works and Utility Committee to provide their recommendations. They reported back after a public consultation process involving hearings at which we presented, and that culminated in the report on the 28th of September. We then awaited what the government's response to the report would be. Well, their response was to pass the bill a couple of weeks ago, 25th of October. Not a lot changed between the original bill and the bill as passed for retirement villages. I think the committee made 3 recommendations, despite a lot more requests than that from industry to change things, and only 2 of those got up, and they were pretty minor. The one that was of real interest that the committee recommended be changed, which we had raised at the hearing, was one of the ones we raised at the hearing. They didn't change. So the entire process has been extremely disappointing. Not law yet, though. We're still waiting for royal assent. Could be any day. So I've made some comments, I guess, on the way through about my dislike for a lot of this bill, but a lot of people have commented it's within industry. It is heavy-handed. It's overreach. It smacks of the government trying to regulate something it doesn't really understand. There is definitely a very strong consumer protection theme to this. That is their focus. And why wouldn't you pre-election, particularly with all the media coverage we've had lately? But the most annoying thing for me is lawyers just want to see good law that can be implemented with certainty, and in a lot of respects this bill falls down. One of the major aspects of it is a lot more new approved forms. So 21 in total new approved forms coming out of this bill, and some regulations to come. Now, we haven't seen any of that yet. That's all still coming. We'll have to wait and see what the government comes up with there. So some of the provisions that are in the Act will not really have any teeth until we get those things. For example, with the approved forms, there's a provision in the Act that says, well, until there is an approved form, the obligation to use the approved form doesn't apply. So we need to wait and see before those things get any actual teeth. The committee's report referred to the need for further consultation on that front. So they recommended that there be, within 12 months, the Minister consult with industry and other stakeholders on these approved forms, on these regulations, and report back. So what we'd like to see, and what we've been asking for, is ongoing consultation. We've been consulting on the Act with mixed success. We want to have a seat at the table in terms of shaping these approved forms, so things like your approved residence contract, etc., because that is going to be just as impactful as the Act itself. In terms of lead times, there's 2 sets of provisions that will commence when the bill receives royal assent, which could be any day. That is the buyback provisions, which we'll talk about in more detail, and also the behavioural provisions, so new behavioural provisions on operators and residents, which we'll examine as well. The rest of the provisions in the bill will commence at a time to be proclaimed, so that could be any time. in the future. It would seem, we've been saying, and I think the government gets this, there will need to be fairly generous lead times. We're talking about wholesale replacement of the documents we've been working with for a long time. People need to gear up to that. We need to see the forms and then have an opportunity to get our templates in order. Budgets, I mean, if there's going to be new provisions, new forms around budgets, the logical time for those to start is 1 July something, whether it's next year or the year after. It really has to be 1 July, you would think. So, in terms of the substantive changes then, the big one is documents. So the PID is going, and I think a few of us shared about that. It is a dog of a document that we've suffered with for a long, long time. It's cumbersome, it's repetitive, and it's good to see it go. Whether it's replaced by something better is yet to be seen. We're yet to see the replacement forms. Pleasingly, whereas the PID under the Act forms part of your contract, and you have this constant exercise of trying to make sure there's no inconsistencies, because the resident then gets the benefit of whichever one's better for them. The replacement documents aren't viewed in that light. They're not part of the contract. You still need to get them right, but the contract is just the contract, the lease or the license to occupy, or whatever model you've got. So what's it being replaced by? An approved form of residence contract, which we're yet to see, a village comparison document, a prospective costs document, and various condition reports. For existing residents, though, who received a PID, their PID will continue to apply to them. And you'll have to keep updating it as you currently do, even after these new forms are in place. So you'll be effectively running two systems in parallel for your existing residents and your new residents that come in after all this commences. There is a provision in the current Act 37.2 whereby if you give someone a notice under Section 36 that there's been there's a material inaccuracy, and it says when you give that notice is deemed to form part of their residence contract. Now, on its face, that means you can unilaterally change the terms of your contract with your residents. Now, I'm not aware of it ever having been tested to its limits, but that provision's going. That even though you'll have transitional provisions that carry on the PID and the requirement to update it as we do now for existing residents, they're deliberately carving out that provision. So they're saying when you give that Section 36 notice under preserved Section 36, you can't materially change the residents' existing rights. So if you have a current need to give a Section 36 notice and you think if it's challenged you might need to rely on 37.2, do it before this becomes effective. So the residence contract, there'll be an approved form yet to see. It'll have to contain additional information to the list of information that is currently required. Those things really are in the current PID. So because there won't be a PID, they've sort of translated those things across. So no big surprises there. There will be a new provision, though, that the government can, by regulation, at any time, mandate that terms must be included in a residence contract or must not be included in a residence contract. So the executive arm of government, not Parliament, can make these regulations at any time that can have a real impact on your contracts and what you're allowed to have in them or what you must have in them, which is a bit of a concern. But those concerns have fallen on deaf ears. So no regulation yet, We don't know. It's sort of a power they want to keep in the back pocket, I guess, so that if they get negative media coverage around an issue, they can always pull that out and say, well, we don't need to change the Act, we're just passing a regulation. You can no longer have this kind of provision in your contracts. So the village comparison document, and this is probably the closest equivalent to the current PID. It's general village information, so not personalised to any particular resident. There'll be an approved form, which we're yet to see. You must have that shown on your website, not necessarily just once. The Act requires that you must show your document, your village comparison document, or a link to it on any page of your website that has marketing material or a link to marketing material about your village. So it's going to take some vigilance to make sure you're actually complying with that. And I'd suggest that's going to generate a bit of work for web designers.
Excuse me, can I just ask
Yes.
Does our village have to have a separate website with other parts of our business?
In the draft bill, it said that you had to have it was the most likely interpretation of it was that you had to have a separate website for each village, but that was changed. So it's clear now that you can have one website that covers multiple villages.
So we run hospital, aged care and retirement village, and we have different sections within the one website for all of those, so we actually have to have a village website on its own.
Yeah, I think that's, yeah,
Okay.
yeah, yeah. So that's the website. You can that's the first obligation around this document. Also, if you're giving promotional material about the village to anybody, other than a general mail out, but specifically to someone, then the village comparison document must go with it. Also, if a prospective resident asks you for the village comparison document, then you have to give it to them within 7 days. If the information in that document changes in a material way, the Act requires that you update that immediately, straight away. But you've got 28 days to tell the department. But the point of it is you've got to make sure that what's on your website is up to date all the time. Prospective cost document. Now this is a summary of the estimated costs for someone moving into the village, living in the village and leaving the village. So it's financial information that a resident wants to know. It's personalised to that resident that you're giving it to. We have examples now in the PID of exit entitlements, exit fees, but they're not required to be personalised to the actual resident or prospective resident you're giving it to. This is going to be different, so it's probably going to be a little bit more work in that respect. And the time frame for giving that is 7 days after the resident gives you the necessary information. So if you've got several options or prices available, once they give you their choices, that's when your 7 days starts to run. I don't think that document's all bad in having it personalised so people can see exactly what they're up for. And the government expressed to me that the rationale in that is at least in part, to reduce some of the angst you can get at the end when the resident has passed away or left the village, particularly if you're dealing with family who weren't involved in those initial discussions. You've got a document that says, to the dollar, this is what we represented at the beginning. So that's the intent.
It's still its estimated cost.
Yes, yes. So I guess I shouldn't say to the dollar. It's
Because
But it is personalised to them in terms of their ingoing contribution.
Stuart, is probably not different to what we do in Victoria. We've got villages in Victoria because we have to do a document very similar showing the 1, the 2, the 5 and the 10-year estimates.
Yeah.
From what they come in.
And has to be personalised.
And it has to be personalised. It's based on the unit that they're looking at and the value of that unit that they're considering and the option they've chosen.
Yeah. So that's the purpose. Condition reports. So there'll now be condition reports in relation to the unit when you enter and when you leave. The process around this is very prescriptive. So you can't commit a resident to occupy the unit until you've gone through this process. You need to do an inspection of the unit in their presence or their representative's presence, unless they waive that requirement. You need to do the inspection in the way prescribed by regulation. We don't know what that is yet. You then need to sign the condition report and give it to the resident. Resident signs it, returns it to you, you copy it, give it back to them for their records. So very, very prescriptive. That's upon entry. Upon exit, it's a very similar process. There's no requirement for the resident to be present on exit, but otherwise it's very similar. If the resident, this is on entry or exit, disagrees with what you've put on the report, then they're to mark that in some way that shows their disagreement. The Act doesn't then go on to say what happens with that information. It's just silent. So presumably that's a dispute and you could follow the normal dispute resolution procedures and take it to the through mediation to the tribunal.
Stuart, is this a vacant condition report? I mean, the reality is that people may not actually remove all the condition and waste days. You could get them most of the stuff and operators tend to, and tags we all are, be quite lenient on those sort of things. So how are we to do a condition report that's still full of...
If they could do further damage. Yeah.
Under the calendar puts vacation date, and that's when you start doing inspections, isn't it? So, I don't think that
I'll just find the section.
Depends on the definition of termination. Is termination the day they advise you, or is it the day they actually make it?
I think it's termination now.
I think it's changed, yes. Is it what's noticed?
I guess if it's terminated and you're still allowing them to occupy, the question is what basis are they now occupying? So, and what terms go with that? So I don't think it'll absolve you of the need to do this within 14 days, but you'd want to be putting other measures in place to say, well, what's the terms you're now occupying on? It all becomes a little bit messy. And one of those terms would be, well, if there's further damage and we're going to do another inspection, which may not be covered by this because their residence contract's no longer in force, then there'll be these consequences if you've done further damage. But I take the point. So it would have been left.
If there's furniture still against the wall and if they take that furniture out, there's a big hole.
That's right. That's right.
It's going to be difficult.
The Act isn't really sophisticated enough to deal with questions like that. They assume that if it's terminated, then the resident is gone, which we all know doesn't always happen. And there's, for both the entry and exit reports, there's an obligation to retain those in your records for 2 years after termination. So this new waiting period that's been introduced is interesting. We already have the cooling off period, post-contract. But we now are going to have a pre-contractual waiting period in addition to that. So at least 21 days before you can enter into a contract with anybody, you need to give them all of these things: the residence contract, the village comparison document, prospective cost document, bylaws, and anything else that comes up in the regulations that we're yet to see. Also, if any of that information changes, other than in a minor way, you need to inform them of the change, and that restarts the 21-day period. So this can result in a fair bit of delay in actually signing a contract, which will then be subject to the 14-day cooling off period. Particularly around 30 June, I can see this playing havoc when you're giving someone a set of documents that has one set of charges in it based on this year's budget, rolls over the next financial year, you reissue it, you've started your 21-day period again. Fortunately, there's a provision for waiver. So if they're prepared to go and get legal advice and have an approved form signed, the 21-day period can be waived. I can see operators adopting that as the norm, requiring waiver, just to ensure that they're not going to get caught under this provision, which has some pretty nasty consequences, or can do, which we'll come to later if you don't comply with it.
Stuart, just a question with the waiver. My understanding is that they don't have to, the resident themselves will sign that they've sought legal advice, but there's no requirement to actually have the lawyer or the firm who provided the advice sign. Is that correct?
Well, it'll be revealed on the form, I think. I'd be very surprised. I think the lawyer would have to sign.
I would think they'd have to identify themselves as a Queensland lawyer.
Absolutely, yeah. It must be a Queensland lawyer.
Mm.
Try and find that section.
I think that Queensland lawyer, and I think we've agreed, Stuart, is quite difficult for someone living, for example, on the Gold Coast, who may go to a lawyer just across the border.
That's right. Or people immigrating to the Sunshine State from Victoria, which is very common. They might have a trusted lawyer down in their home state that they want to use, but they won't be able. They can still use them to get advice, but they won't be able to sign that waiver. No. And I guess the rationale is the government wants the consumer to be protected. They want them to get advice from someone who's registered to practice in Queensland, seeing it's a Queensland Act. Not that necessarily means a Queensland lawyer knows anything about this Act, as we all know from the various questions we get from residents' lawyers from time to time. So it's an interesting requirement. People did make representations through the consultation period that it be widened to any Australian lawyer, but that wasn't accepted. So, I mean, I think the waiver will become important, particularly for villages that provide a lot of care, where people really need to get in straight away. That's when they're likely to require that that be waived, rather than waiting potentially 5 weeks. It's 5 weeks once you allow both periods. With operators should not be obliged, they can choose to, but they shouldn't be obliged to let people in before the end of the cooling off period, because they're running that risk that the resident will cool off and then the unit has been damaged in some way. New provisions around getting access to documents. So there'll be a new definition of operational documents, which are going to be prescribed by regulation. We don't know what they will be yet, but one can imagine they might relate to budgets or annual financial statements, perhaps. It'll be information that the average Joe public would want to know about your village before coming in, I would expect. They can be requested not only by existing residents but also prospective residents. So, a prospective resident could be virtually anyone. So whatever operational documents end up being will effectively be public record, because anyone will be able to get them from you, and you have to give it to them. You get 7 days notice to give it to them. There'll be a fee to be prescribed by regulation, and a carve out. So if it's personal information about someone, this won't apply. You won't have to give that to them. So if it's perhaps the retirement village manager's wages or their employment file, something that identifies a person or is capable of identifying a person, then that's going to be personal information that is carved out of this obligation. Exit entitlements. Been a hot topic. There's been a lot said about the merits of this. It's been a losing battle, I guess. It is something the government was absolutely intent on doing, and it's now arrived. The main question was what would the period be? Thankfully, it was 18 months. The other options that were in the mix were sort of 6 and 12 months, but they've gone with 18, and that's, I guess, it's something that we can't get around now, notwithstanding the objections that have been aired through the consultation period. But if you stop and think about the issues that this is going to pose, it is concerning. I've spoken to operators who said this is going to mean we're going to need to have to increase our costs to people on the way in to cover this risk of having to pay people before we've sold a unit, if it hasn't sold within 18 months, which just reduces the affordability of this segment of the market for people. Our bank, we're concerned about our bank and what their requirements might be in terms of LVR for our loan. It suits the larger players, so they've got the deep pockets. It's less concerning for them. But if you've got a single site, small village, and you've got a number of vacant units, it can be a real challenge, I guess. You could be legitimately very worried about that. So, you can see industry consolidation arising because of this, which again just reduces choice for residents. And my question is, well, is this actually going to precipitate some village failures by villages that are marginal? Because once you sort of start having difficulty paying one resident in time, and the word will get out, then will it be a race for the exit? And whereas normally you could have got through it, but will this precipitate a village failure? And we haven't had that many, but who knows with this, which would be contrary to what they're trying to achieve, because that really, who does that hurt? That hurts the existing residents who are trying to sell. So anyway, we've got it. So if the unit's not resold within 18 months after termination, then you need to pay the exit entitlement anyway, based on valuation. That in itself is a concern, that the time period is measured from termination and not from some later period when you've got your reinstatement done, your valuation done, and the resident's actually out of the unit. And that's when the sale process can actually start. But no, it's from termination. So all of those processes are eating into your 18 months. They have, I guess, tried to ameliorate the impact of that for industry by including hardship provisions. So if the operator alleges that paying the exit entitlement without a resale would cause them hardship, they can apply to QCAT for an order that extends the due date QCAT can also order that be paid by instalments. Now, I think that is really of limited utility because as soon as you do that, you know, how many new residents are you going to be attracting realistically if you've publicly applied to QCAT to say, well, I can't pay exit entitlements within 18 months? You know, your bank's going to be all over you asking questions. I don't know how much utility there is in that provision, which is sort of the olive branch that was offered to industry in exchange for the 18-month buyback. The real kicker is it's not just prospective residents. It operates retrospectively. So everyone in your village now is going to be caught by this as soon as Royal Assent comes down, because that's when all these buyback provisions begin. The one transitional provision is if when that assent is given, the contract has already been terminated, then your 18 months still applies, but it'll apply from whenever these provisions commence, not from when it was terminated. So if it was terminated 6 months ago, it won't start then, the 18 months will start now, but you'll still have an 18-month period. But even that contract does not escape completely. One concession that was offered out of the Parliamentary Committee's review was that the Minister has to conduct an independent review, or at least commence an independent review of these provisions within 2 years after their commencement. So we'll all come back and see how they're impacting industry. Another bright spot we in the bill, and this is something we pushed for, was that we've now got a provision similar to the Aged Care Act, whereby if you haven't been, for a deceased estate, deceased resident, if you haven't received probate or letters of administration, you don't have to pay. And the rationale for that is you may not know who to pay. Not uncommon for estates to have infighting for control. Who's the properly appointed executor? Is this will valid? No. This one, did they have capacity when they signed that will? You may not know who to pay. At the moment, before this provision, you just have the obligation. You must pay within 14 days after settlement of your resale. But if you don't know who to pay, well, what do? You breach the Act, or you potentially pay it to someone that's not entitled to and risk a claim. But now we've got this provision similar to the Aged Care Act. So, and this overrides any other provision about timing of payment of the exit entitlement, including the 18-month buyback. So until you get probate or letters of administration, you don't have to pay until 14 days after you get those things.
Is that going to start?
That's a good question. I don't believe it is. I don't believe it is, unless the proclamation says so. Yeah. So if it doesn't, we need to contact our representatives and say, well, this needs to start now. So general services charges then. Some major changes here. They did tidy up a lot of the terminology, which was a good thing. You might remember from the Ash decision, there was a lot of criticism of different phrases being used through the Act. You know, general services charges, which wasn't defined, charges for general services, and do these mean different things? So they tidied all that up, which was good. In terms of things that really impact us, though, there'll now be a requirement for a general services charges fund, which we haven't had before. I know a lot of people do have one and keep those monies separate, but now you'll have to. Based on previous QCAT decisions, you would say that that means a separate bank account, not just a separate ledger account. The sole purpose of that fund is to provide general services, so you can't use it for anything else. there's a new provision that you can't include in your general services charges legal costs in relation to a retirement village issue, which includes a retirement village dispute. So that becomes relevant when we start talking about operator involvement in resident versus resident disputes a bit later, but that's a new provision. The next dot point there about operator liability, so that's referring to section 105, where if you've got an unoccupied unit or a unit for which there is no residence contract, the operator's got to pay the general services charges for that. That's the existing situation. What they've done is to try and define what accommodation unit means for the purpose of that, and it includes a unit under construction. But they don't tell us what under construction is. The concern I raised at the committee hearings at great length was that that could mean as soon as you start laying your foundations for a block of units, all of those units are under construction. So that's your second tower in a campus-style village. All of the residents in the first tower have now had their general services charges subsidised by 50% because now the operator's got to pay general services on all these unconstructed units that are basically airspace at the moment, and the residents in the first tower still pay theirs. That was the issue, one of the three issues that the committee recommended be changed. They recommended that a unit not be considered a unit for the purpose of that section until you've got a certificate of classification that says we can lawfully occupy this unit, and the government ignored them. They just left that section as it is. So that's going to present some difficulty potentially. Now I know that developers of villages often are subsidising the GSC anyway to keep it at a marketable level, and because of the Ash decision, that confirmed that they've got a fair bit of flexibility around that. This, I think, at the very least, reduces that flexibility. So if you're subsidising GSC while your village gets up to maturity, then you're going to have to at least allocate part of that subsidy to your Section 105 obligations in your accounts. I think you're going to need to say, well, I'm responsible for these units under construction, so that's my Section 105 obligation satisfied with that chunk of money, and the rest of it is my subsidy that I'm putting in as a good operator in the development phase to keep itself affordable for people until we get critical mass of residents. That might be oversimplistic. May not work that way for every development. So it is a problem. It's going to have to be carefully managed if you're in that space where you're developing a new village or you've got several stages. They can't say they weren't warned. They can't. They were told repeatedly that that's a problematic provision. So, any operators here who are developing have a view on how you're going to handle this?
I haven't got an answer for that yet. I'm waiting for it to be popular to get royal assent.
I'll just go 0 value.
Yes, that's right.
Because it's not constructed, there's no cost.
We're on the precipice of looking at some redevelopment with
Yeah.
so it's going to capture us.
Yeah.
There's no question.
Yeah.
There's a real chance that you would just
Yeah.
We just put a line entry, and the line entry is 0 because the action costs.
My concern is to ensure that if it's challenged, and general services charges are one of the most challenged aspects of the Act in QCAT, that you can show some rationale, paperwork trail that can defend your position to say you've complied with this. I can see the difficulty if you've just said, well, for our allocation is that units under construction, the general services charge is allocated to them as zero, because then you might run into problems with the CPI cap. So once that unit's constructed, it has a nil general services charges up to then, and then you want to charge proper general services charges for it because the residents now moved in, far greater than CPI increase. So it's how to work around that. They clearly haven't thought about this.
Depending on the scale of what it is that you're actually doing, it quite significantly change the general services budget anyway.
Yeah, that's right. Yeah.
So what do you charge all the people in this part for a budget that is going to cover this much?
Yeah.
When this much actually hasn't been built, I wouldn't be very happy about that either.
That's true. Yeah, that's true. Yeah, once you've got more infrastructure in place, the total of the expenses for general services charges is greater. But
that flows on to the MRF component.
That's right. So it'll all work out in the wash, but during it's the development phase where it's difficult. Perhaps there's a solution around rebating. So your general services charges for each unit constructed or under construction is a fixed amount. There's another clause in your documents that says, well, we're going to rebate these ones. So then you can sort of argue, well, we're not increasing by more than CPI because the underlying general service charge amount for the units under construction was still X. There was just a rebate back to them because they weren't actually using any services. There was no one in it. So anyway, it's not an easy one to deal with and shouldn't be there, but we need to deal with it. And that's a potential way to deal with it. They've tidied up the provision around which quarter you use for applying your CPI cap. So they've said it's the third quarter of the financial year. So it's now clearly March. MRF. So MRF contributions are no longer part of GSC. They've been separated, which makes sense. They're totally different budgeting procedures. They have fixed up the problem with the original bill, which meant that freed up MRF from things like your 9-month cap and your 90-day cap for former residents. They've fixed that up, so MRF are now caught by that as well. Your budgeting process is now more restrictive. So whereas previously your quantity surveyor made their recommendations and then the operator had a discretion to implement that, but to vary it to take into account circumstances that the QS haven't fully appreciated, that discretion's removed now. So now you have to follow what the QS tells you unless you get a special resolution. Really, I think in practice what that will mean is closer engagement with the QS before they issue their report, even to the extent of getting them to issue you with a draft report, which you then sit down and discuss with them. And now any resident, not just the committee, can ask for a draft MRF budget. Reinstatement and renovation. Now, these are problematic provisions. Again, they seem to have completely missed the point on the changes they wanted to make here. I do recall during consultation there was a lot of discussion around we need some controls around renovation. We're only talking about reinstatement. So they've tried to do that, but they've really flipped it all on its head. I don't think they understood what the problem was, not that there was such a problem. Reinstatement has now been differently defined. It's going to be replacement and repairs that put the unit back in its condition on entry, but excludes fair wear and tear and agreed changes to the unit that were carried out. So it's a very limited scope, and it doesn't seem to me that it's all that greater in scope than accelerated wear, for example. So the responsibility for that lies with the resident. Then you've got renovation work.
Can I just go back to the exclusion of the agreed changes carried out? So does that mean if someone comes in and they decide they want to fill in the veranda, we can't ask them to strip it back for the next
Yes, that's,
resident?
yeah, the way it's worded, and it has this exception for, in terms of what the resident's obliged to do for these agreed changes. So if the resident and the operator agree at the beginning that a pergola will be put on, for example. Yeah. So they've agreed to make that change. That's excluded from the reinstatement work that the resident's responsible for.
And that's often the only reason that you agree for them to do it.
Exactly right. So it's going to discourage operators from agreeing, even if the resident says, I'll pay for it to be removed, I'll pay for it to be repaired and maintained, just let me do it. This isn't going to allow you to force them to pay for it to be undone directly. Now, if you divorce the payment from the obligation in some way, so you have a second component to their exit fee, or you charge them an administrative fee at the beginning to cover the estimated costs of removing it, that'd be okay. So you're going to have to be a little bit clever about it because of this problem they've introduced.
So they're not responsible for any maintenance on that particular item either during the tenure that they're
Doesn't
there?
say that. No, it doesn't say that. No, it's just about removing it. Yeah. Yeah.
Who's defining fair wear and tear?
The general law. There's no definition in the Act. Yeah, there's case law on what fair wear and tear means. It's essentially around normal use and the elements. Actually, I think they did put a fairly useless definition in there. I think they just substituted fair with reasonable. It didn't add a lot here. Fair wear and tear includes a reasonable amount of wear and tear associated with the items commonly used. So fairly unhelpful, but there is case law around what fair wear and tear is. But I would regard the normal recarpeting, repainting as fixing fair wear and tear. So they're now saying, well, that's not reinstatement work anymore. That's renovation work, which is everything else. All other repairs and replacements are now called renovation work, which the parties share in the same proportion as the capital gain sharing, which is the same now. So I'm not sure what they were trying to achieve in doing all this, but it's a new suite of provisions we need to become familiar with. There's no mention of restore it to a marketable condition like we've got now. So it's going to involve a different mindset.
So what if there is no proportion of capital gain?
If you don't share it, so the operator keeps 100%, then the operator will pay 100% of the renovation work, which is similar to what we've got now.
Mm-hmm. But it will include, obviously, a few other things.
Well, it could do unless you find a way around that. It shouldn't be hard, but you just need to draft it appropriately. What's missing now one of the big problems with that is that it's so it puts the obligation on the resident to do that reinstatement work. So residents aren't going to do it. We don't want residents doing that. We don't want residents doing anything to the unit. We want control of all that process. So that's problematic. I think the operators need to take control of that and draft provisions to force the resident to appoint us as their agent to do it effectively. We can't have residents. I mean, you don't have control then over what tradesmen they bring in and approving them. It'll slow the process down. There'll be questionable quality. A resident might injure themselves. Who's responsible for that? You need to take it out of the resident's hands. So establish that agency relationship in your documents.
Have you got a clause you're thinking about already?
Absolutely. So it is very different. There's no obligation now on parties to agree on what the renovation work, which is essentially like the old reinstatement work, is actually going to be. You used to have to agree on what work you were going to do. You don't have to do that now. That's gone. Doesn't mean it's open slather though, because it is defined by reference to replacements and repairs. So anything that's an upgrade is still going to be outside that scope, and operators will be responsible for that. What they've inserted instead, though, is this obligation before you start any renovation work to agree on the date by which it will be finished with the resident. And if you can't agree, you now have a dispute, which can then go through the regular dispute resolution channels. So that's just going to slow everything down. It's ridiculous. Our solution to that is to say, well, the requirement is that you agree before you start the renovation work. It doesn't say you have to agree after the agreement is terminated. So in your contract, that's the time to agree. So set a reasonable time frame, say 90 days, but have it subject to extensions where the reinstatement work is delayed for reasons beyond your control, something of that nature. Then you've ticked the box, yes, we agreed, this was our agreement. It was 90 days with potential extensions. It was agreed before we started the reinstatement work. Might have been 10 years before, still before. That'll tick the box. Then you don't have this complication of having to agree this date and then being wedded to that date with real consequences if you miss it. At a time when, if the resident's passed away, you're dealing with a family, they're emotional, you just don't want that hassle. They don't want that hassle. The other thing to say is that this is not retrospective, so this will only be for new contracts after these provisions commence. So you'll still be running your old regime for all your existing residents up to then. Okay, let's leave that. It's all a bit of a mess. Behavioural matters. This was flagged for some time, that there would be provisions around respecting people's rights, not interfering with their reasonable peace, comfort and privacy. So we've got those now. In terms of protecting the resident, the operator can't interfere with those things. The operator must also take reasonable steps to ensure that other residents or other residents' guests don't interfere with resident A's peace, comfort and privacy. What are reasonable steps? Well, enforcing their contract, I would suggest, at the very least. Potentially also to the extent of taking them to QCAT if they refuse to comply, or giving them a termination notice, possibly. The costs of that, the operator being dragged into a resident versus resident dispute, you're not going to be able to pass on as general services charges because of that other provision that we mentioned before. It doesn't say you can't recover it from the offending resident, though. If they've breached and you've suffered loss, maybe you can bring an action against them. But in terms of putting that in the pool of your administrative costs and sharing it amongst everyone as general services charges, you can't pass on the legal costs in that way. I can see resident v resident disputes dragging in operators because of this provision. Residents will work out that you have that obligation to get involved.
The trouble is that they're slightly dementia.
That's right. That's right. Yeah. I mean, you would want to keep a happy village anyway and intervene early is the answer before it escalates, as you would do. But sometimes people are intractable and they just want to have their day in the tribunal and be heard. And the risk if you don't is that the resident who's suffering at the hands of the other residents' offending conduct can point to you and saying, you're not complying with your statutory obligation to protect me. That's the effect of this.
I assume this is retrospective.
It will apply to anyone in the village. Yeah, once it commences, which will be on the date of royal assent. Could be any time.
So all we have capacity in our agreements to basically put a clause in that says that if you're dealing with behavioural matter and we've got costs, we will cost it back to you.
I don't see any reason you couldn't do that. Yeah, there's no pecuniary penalty under the Act in terms of, we'll come to it, the residents have got similar obligations on them in terms of their conduct, but there's no pecuniary penalty on them mentioned. But I don't see why you couldn't make that a term of your agreement. So your agreement would overlap the statutory obligations, but would add on a right to recover damages. You'll have a general damages provision anyway, I'm sure, to say if they breach and we suffer loss, we can sue you. Yeah. All right. If you receive a written complaint, question or proposal, then you must respond to it within 21 days in writing. It must be a complete response, which is simply a written response that addresses each complaint.
Basically, you're saying it has to be resolved within 20.
No, not resolved. Doesn't say resolved, just addresses. Yeah. But that time frame is important. And it can be a complaint or question or proposal, not just from a resident, but also from a former resident or a representative, which means essentially a resident advocacy group like ARQRV. So if they write to you on behalf of one of your residents, you've got 21 days to give them a complete response. Similar provisions on imposing behavioural obligations on residents as well, which was good to see. Good to see it works both ways. So they have an obligation not to interfere with other residents' peace, comfort and privacy. They also have an obligation to not interfere with the operators and their officers, employees and agents' right to work in an environment that is free from harassment and intimidation, and allows for occupational health and safety. So that's a good provision. That makes sense. If you think back to the Mitchell case a few years ago, where Mr. Mitchell up on the Sunshine Coast was being belligerent to some AVO staff. He was waiting for them in the car park when they'd go to their car and blasting them with all kinds of complaints. And AVO took him on and said, well, we have a duty to protect our staff. Our directors are personally liable. This is a non-delegable duty, so you need to stop it. And they were successful. This kind of provision will be useful for that. One of the changes that's come in when the bill was passed compared to the original bill is this last one, misleading and deceptive conduct. So this is around Section 86. Section 86 previously said you can't give residents or the department a document or information you know is false or misleading. That's now gone, and it's replaced by a general obligation not to engage in conduct which is misleading or deceptive or likely to mislead or deceive. So that's only come in the last couple of weeks.
We have an entire national suite of legislation.
We do.
Department that actually does all that.
Yeah, I mean, the wording is taken straight out of the Competition and Consumer legislation, Section 52 of the Trade Practices Act in the old language, so which many of you would be caught by anyway. So this is really just another string to the bow because, for a start, it removes the element of knowledge or intent to mislead, because previously that was a requirement. Now it's not. So even if you accidentally give someone something you thought was right, it's not, it's still misleading. It's still an offence. And there's a pecuniary penalty, and the resident can apply to QCAT to have their residence contract set aside. which means refund of their income contribution potentially. And there's no time limit for bringing that kind of claim. Yeah.
So do they get the entirety of their?
It's something that the QCAT could order if they
In
order.
spite of the fact that they lived there for 7 years.
Yeah. Well, the longer they've lived there, then I guess the less likely QCAT's going to order that. They wouldn't have to order that, but potentially they could. I think they'd be more likely to order something like that if they've only just moved in and something material had been misrepresented, and they said, well, I would not have entered into this contract if I had known this.
So what about residents misleading the operator?
That's not provided for in there, and I don't believe the national legislation will catch them either, because the requirement is that it's in the course of trade or commerce, and the resident's not going to be doing that. But it doesn't mean that you won't have rights, not have contractual rights if they've represented something to you. What's an example you're thinking of?
I wasn't really, but I mean, you do get residents that do have big white eyes.
Well, I can think of an example as if you provide care in your village and you're dealing with the family and they're representing the state of health of the resident, and when they arrive they're much worse than represented. That would be misrepresentation. The trick would be to try and bring that in to a provision of the contract, because then you can rely on contractual obligations. So maybe there's an acknowledgement form that's either attached or referred to in the contract, if that's part of your business model, that you provide a lot of care. Maybe you want to think about doing that. Without that, sort of relying on non-contractual remedies of equitable remedies of misrepresentation, which is not as clear cut. So if you can bring that in and make that a contractual term, you're in a much better position.
So just something to pop in my mind about, there was the term prospective resident used in terms of providing them with documentation that they requested. What makes them a prospective resident?
Well, as I said, in context of the operational documents, it's virtually anyone. There's no definition of that. So anyone that says they're thinking of moving into your village.
Yeah, but they're only prospective resident if we include them in our code.
Granted, yeah, if they don't exceed your minimum age, you could argue, well, they can't be a prospective resident because we wouldn't allow them to live here. Yeah. But you might be dealing with their children on their behalf. One of the kickers with misleading and deceptive conduct is, if you look at section 224 in the Retirement Villages Act, you're deemed to be conduct of your representatives, for example, your on-site manager, within their actual or apparent authority is deemed to be your conduct, unless you can show you've taken reasonable steps to prevent them engaging in that conduct. Ostensible authority or apparent authority means that they don't actually have that authority, but the person they're dealing with, the resident, reasonably believes they do. Pretty low threshold in that context. So it really highlights the importance of having good training manuals, training sessions and procedures so that your managers, other staff know what the boundaries of their authority are in terms of what they're allowed to represent and not. But there's some controls around communications in writing. There's some disclaimers. For example, the decision of Cassar and Blue Care a few years ago, where Mrs. Cassar was trying to allege an agreement had been reached to transfer her from one unit to another. No documents were signed, but there was just an email trail that very nearly was legally binding. that kind of thing. If there'd been clear communications in that context that this is not intended to be legally binding, it's subject to formal documents being entered into at the bottom of every email, verbal conversations promptly confirmed by email to Mrs. Cassar, then Blue Care would have been in a much better position. But as it was, they very nearly lost that case. I'm aware, conscious of time. The next few slides are really around that trio of provisions that have very similar patterns in terms of transfer of control of a village, selling the village, closing a village or redevelopment. So I won't go through those in a lot of detail. It's safe to say all three of those now need approval by the department. You need to give notice to the department if you're doing this. Originally, they had no time frame whatsoever in which to respond. The bill as passed now has a 90-day time frame for each of those approvals. But the 90 days runs from the later of when you make the application or you give them any further information they ask for. So they can really extend that out by asking you for further information. There's still no criteria around how they make their decision, other than very generic wording. For example, with the sale of a village, the transition plan that you're looking to have approved has to provide for a clear, orderly and fair process.
So when do you think this one might come into play?
On proclamation, yes. The other thing they've introduced for this one is a grandfathering clause. Wasn't there in the beginning, so they've now realised, well, that's unreasonable. So if you've entered into a contract before it commences, it won't be caught. But any contracts entered into after that, this provision commences, are caught. So the process essentially is give notice to the department, we're selling the village. Within 28 days, here's our transition plan. The department then may invite submissions from anybody who's interested. Could be residents, could be staff.
So what level of liability does the department have for making a sale fall over because they drag it out for so long?
Oh, none.
Buy against something else?
No. Well, if they don't approve within the 90 days, and this goes for all three types of plan, it's deemed to be approved. So, but I can see them taking the full 90 days, for sure. The big concern for me is that, particularly for sales, if they're inviting submissions from residents and staff potentially, that's the sale process is something that you typically want to keep confidential. It's a business sale, because as soon as your staff know, they're looking for other jobs, which then drives down the efficiency and the value of the asset you're trying to sell.
Also has major implications where there's a listed company involved as well.
Exactly, yeah.
Because once something like that goes,
Yeah, they need to
likely that they're going to ask
announcements.
for submissions, then
Yeah.
they have to actually go and sell the market.
Yeah, that's right.
And maybe it's be simple due diligence a bit.
Yeah. Yes. Well, that raises the question, well, when do you propose to sell? Because that's when the obligation arises. Is it when you have a board resolution? Is it when you start asking for EOIs? Is it when you sign a contract? I'd like to think it's when you sign a contract. I don't see how it works any other way. So it's an offence not to transfer control of the village without an approved plan, must comply with the plan, keep the department informed if they ask you to about how it's being implemented. One of the major issues with it, though, is the department's ability to, after they've approved the plan, step back in and say we want you to revise that in these ways at any time. This could be the day before settlement. So I think what you're going to see is people having their settlement date almost immediately after they get that approval, so within a week, I'd say, 2 weeks max, just so that the department doesn't have an opportunity really to think about it and make changes.
What's the problem they're actually looking to solve?
I don't know why these provisions are in there in the first place. Why they want control. It's not like we take government subsidies. But consumer protection, I guess they would say. Well, good question. The point I made at the committee hearing was the contract protects the resident. It doesn't matter if it's seller or buyer, they're still bound by the same contract. But no, they've taken a policy decision that residents need to be allowed to have a say as to who their operator is, because the new operator may change things for them.
The reality is that they don't have a say.
Well, they do now.
They can't stop it.
Well, the department can stop it, and the department
the department
can
can
invite
potentially
submissions.
actively obstruct,
Mm.
in which case I would think that the operator has grounds to sue that individual.
When you say sue, I guess when you're talking about a government department, you're talking about judicial review. So yeah, you can take them to the Supreme Court under judicial review, say that's not a reasonable decision that any reasonable decision maker could make. It's a pretty short time frame, so I think you've got 28 days after the decision to bring that kind of action.
The reality is it's just going to be down to the individual whims of that person in the department looking at it.
Well, that's right. Well, at least with the Aged Care Act, you've got a similar provision in the Aged Care Act. I know they take government subsidies, so it's a different ballgame. But there's actually criteria in the principles about what they look at in making the decision and deciding whether to approve the new operator. There's nothing like that here, other than that general provision that's got to provide for a clear, orderly and fair process. What does that mean? So, look, whether it'll be a problem in practice, I don't know. I think everyone will now have to make their contracts of sale conditional on getting this approval within a certain time frame. You'll have to allow at least 90 days and you will want to settle straight away, I think, to reduce the possibility that I'll step back in and revise the approved plan, because that has to be at someone's risk. If the contract says no more, it's at the buyer's risk, because the approval's been obtained, conditions satisfied, we're going to settlement. If the contract instead says, well, the buyer can terminate if this happens after we've got our initial approval, well, it's the seller's risk. Someone's got to bear that risk. So having that short time frame between condition satisfaction and settlement reduces the risk. So I personally said to them at the committee meeting, committee hearing, I think that's probably the most offensive provision in the whole Act. Similar provisions for, sorry?
I'm interested in this one. What do you want to do here?
Redevelopment, yes. So similar pattern. Need to obtain approval for a redevelopment plan. That can be approved by residents in special resolution or by the department if you can't get that special resolution.
So is that a redevelopment of the community centre, or is that building a tower beside it?
Well, let's talk about what redevelopment means. It's very broadly defined. It can be construction of a unit, demolition of a unit. Construction, demolition or expansion or reduction of a building other than minor works, increasing or reducing the area of the village, so if you amalgamate other land or hive off other land, that's a redevelopment. Changing the use of a building other than in a minor way. So if you're building a shed or something minor, that's not going to be a redevelopment. But if you've got a stage development, that is a redevelopment. You're building a new unit, at least one. So that's going to be caught unless you get the benefit of this transitional provision, so that if every single resident in the village, no exception, has been given written notice of the redevelopment before they became a resident, either in their PID for existing residents or these replacement documents that we're yet to see, then you're fine. You've given that notice, you don't need to go through this process. So in the PID, you've got section 2.12, which talks about how many units will the village have when it's complete. I would like to think that that's sufficient. If you've filled that in appropriately, you've ticked the box. So keep doing that, as long as you haven't missed anybody, because you need every resident to have been notified in writing of the redevelopment before they became a resident. Can't be cured afterwards.
Has to be specific numbers, or it can be a clause.
Good question. Yeah, it's not that sophisticated. It says written notice of the redevelopment. The best drafting you could have would be to have those kind of reservations, and we've been using that for a long time, to give you that flexibility. So the residents informed, they've agreed to it by signing the PID, that this is what we're planning, but we may change that. I would like to think that's effective, but who knows? Until it's tested by the tribunal, we won't know.
You're already halfway down the track in terms of your redevelopment before those are allowed to come. When do you have to tell the department?
Has every resident received notice?
They would have. You did.
If you can say every resident has received that notice, then you don't have to do any of this.
Okay, so.
So what if you want to convert, say, a unit into like a community space or something like that?
It's a change of use of a building. That is probably not minor, I would say, that kind of use. If you're changing the craft room into the indoor bowl centre, that's probably minor.
So this isn't effective until it's.
That's right. Proclamation. Yeah, no, proclamation. So it could be effective. Yeah, the only ones that are going to start straight away on assent is buyback and behavioural.
Okay.
Yeah.
And then there's proclamation.
Everything else is whenever it gets proclaimed.
Right.
Could be next year sometime.
Okay. That's right.
Yep.
What you're saying here, what appears to me, is that our PIDs now are not going to be simple. They're going to be a lot more involved, because right up front, we're going to have to put a lot more things in the PID to cover all these.
Yeah.
Well, instead of PID,
the replacement document. Yeah. So
where's the simplification?
that's a good question. Yeah. That's the problem with, particularly with prescribed forms of residence contracts. If it's still going to allow flexibility, you're going to have all these annexures attached to the back of it. So it's still going to be a pretty long document.
And again, which is the problem that was being solved here? Endemic to the industry.
Yeah. Look, I guess it's a lesson in, elements of the industry were asking for redevelopment clauses because to give them that flexibility, because your stock ages and you want to redevelop it, and you need to move people out of it to do that, which is difficult if you've got to get 100% consent from all the residents who've got tenure in those units. So I can see some sense in it, but they've really gone to town with the process. So, not understanding what they're regulating, I guess. And then the problem is really around the breadth of that.
Even in this, there isn't any, it doesn't solve that for the operator. It doesn't say, there's nothing in there that says, you can actually tell these people that they need to actually go over here or you redevelop these.
Yeah, that could have been a lot clearer. It just says, go and get a special resolution or anyone.
And one person can say no. So.
I guess you're trying to, it leaves you to infer that if you've got that special resolution, you're allowed to proceed. But yeah, it's a bit unsatisfactory.
When do you get the special resolution? Like at what stage?
Has to be before you implement it.
And if you can't get it?
Because if you can't get it by special resolution, you can then go to the department. But then the department will give notice to all the residents that the application's been made. They'll invite submissions. If the resident asks for a copy of the redevelopment plan, they'll give it to them. Then you've got your 90-day period for it to be approved.
So building a new building, you can't call it a development and not a redevelopment. Just building a new building, it all falls under redevelopment.
Well, it's so broad. Yeah, it doesn't matter what you call it. It's so broad.
So really what it means, Stuart, is that operators potentially, well, effectively can't redevelop something. So this is a pretty, we use the ABA Newmarket, for example.
Yeah.
With this sort of division, they will never be able to do that.
I don't know their specific situation in terms of what they've already represented to residents, but I agree it'll be difficult. It has been difficult for them so far, even without this provision, because they didn't get 100% buy-in, I understand. But if you have given written notice of the redevelopment to every single resident, you don't need to do any of this. You just have to happily proceed with your redevelopment. So if you've disclosed to everybody, yes, we're building 5 stages, approximately this many units, we reserve the right to adjust that, depending on market conditions and approvals.
You can really only do that on a brand new development, okay?
If you haven't been including those kind of provisions, well, the PID forces you in 2.12, and has for a long time, to reveal how many units it will have when it's complete. So that's the place to start if you want to assert that you've escaped these provisions. Go back and look what you've said in 2.12 of the PIDs. That might be enough. If someone challenges you in QCAT and you say, look at 2.12, we told them there'd be 140 units when it's complete. They know to get to there we need to be constructing. So we've revealed.
But as I say, it's only going to be where you start to bring new site and everyone comes in on those terms that you can continue to develop that way. Whereas if you have existing sites, it becomes incredibly difficult because you don't already have those provisions in there. Or if you acquire a business with a view to developing it, so you buy something in a cracker of a site, you've only got 70 units on it, and you know with planning approvals, etc., you can put 4 or 5 stories on there and put 200 on there, but you essentially have to wait for everyone to die before you can do it.
Or sell it to them and
Can you, I mean, realistically, they've got you tied in knots.
well, you need to get 75% of it at least. Yeah, it's going to be an important due diligence aspect, isn't it? Buying an established village with spare land, you're going to want to know what's been represented. Am I going to have to go through these hoops or not? It's very important.
And anyone can throw a spoke in at any time on this.
Well, special resolution, 75%. So
Yeah, because then you don't have to go to the department.
No, that's
for
right.
any of it.
Yeah, that's right.
That's the key.
So before this
Something
comes
notified.
out,
Sorry?
our solicitors got us to take out the numbers that we had in our original contract because we can build a time frame. So we have a first set who've got more numbers than the next set that came into the next stage of our village, and then we have not built the next stages. So the solicitors advised us to take that out, but we have a clause that says we may build in the future. So if we put a change to the PID, notified the department, gave it to all the residents, you could actually amend the current contract before the proclamation of that clause, and would that get you out of trouble?
The difficulty is they need to be advised in writing about the redevelopment before they became a resident. So if they're an existing resident, you can't do anything. You have to go back and look at what they were notified of before they became a resident. But I would think it would be unreasonable for the tribunal to say you are stuck with whatever unit numbers you represented to the exact number. I think you'd have a fairly good case to say, well, these things are inherently malleable. We've disclosed we're redeveloping. Any resident should realise 1 or 2 units here and there is not an unlikely scenario. It makes no material difference to them. The important thing is we've disclosed that there'll be dust, there'll be new buildings, there'll be noise, new residents. In essence, we've disclosed what was happening, and they're no worse off because we built 143 units instead of 142. That's the argument I'd be putting. I'd also want to have those reservations expressly stated, so you can say, well, the resident agreed that we could be flexible with the numbers. If you don't have that for all your past contracts, then you're relying on sort of implying those terms, I guess. So village closures, hopefully we don't have too many of those. They're a very similar pattern, need to have an approved closure plan. The department will notify residents when they receive it. Can be approved by special resolution or the department, 90-day time frame, or else it's deemed to be approved. And if you're terminating a resident's contract because of village closure, you've got 14 days to pay the exit and toll. So just quickly, valuations. For revaluations, it's every 3 months now, not 6. Where you're paying under the 18-month buyback, so you haven't got a resale, you have to have a valuation within that last 14 days before you have to make the payment.
When do you agree value at time of entry?
At time of entry.
So you get paid out next installment based on what you paid.
Do you mean the new ingoing contribution is irrelevant to what they receive? Yeah, well, we asked for that. So, well, why do we need a valuation if it makes no difference to the amount they get? It wasn't changed. So, but what's going to happen if you don't do it? Really, if they're still going to get the same amount of money in the same time frame. So who's going to complain?
That's a good one.
It is unless, sorry, there's an exception for unless otherwise agreed. So, but I guess agreeing on the formula for paying their exit entitlement doesn't have regard to the end value. It's probably not the same thing as agreeing on the value. So you don't have to do a valuation if you agree on the value.
Yeah. Right.
Yeah. But who is going to complain if it makes no difference to what they receive and you just don't do the valuation? You're not complying with the Act, but your risk is pretty small, I'd suggest. New processes for the valuers. So they now have to, this is not just for that 18-month buyback, but for all the valuations for whenever someone leaves the village, you've got to do that initial valuation and then revalue after 3 months now. The valuers doing those need to invite submissions from the parties. They need to assume the village is operating normally, so if it's being run down, they need to ignore that, make sure the resident's getting proper value. They need to have regard to